Okay, so we all know that there is like this lawsuit, and it kind of like came and went. I think that the drama with Concord and Assassin's Creed kind of drowned out this lawsuit. But this lawsuit, I think, is actually kind of like potentially industry shaking. Um, so they announced this lawsuit against Palworld. Now, let's see. Do I have an art? I thought I had. Okay, I don't have the initial announcement brought up. I should have, but I don't. But I could kind of give it to you anyway. Nintendo filed this very short statement, say that they were suing Palworld over patent infringement. Okay, and they didn't say like what patents or anything. And the most interesting thing about it is specifically patents. So not IP. Not copyright, patent. So they're not going after the character designs. Okay, they're going after game mechanics, specific game mechanics within Palworld. So there is this attorney who narrowed it down about what the infringement they could possibly be suing over. So look at, let's see, I'm going to go ahead and just read this, but the list of like a candidate, because they've got like hundreds. I mean, Nintendo has like, honestly, like the country of Japan alone has like half of all the patents in the gaming space. It's kind of crazy because Japan's patent law is really fucked up. Okay, so the other big thing is after the announcement, Pocket Pair still wasn't aware of what patents they infringed upon. Okay, so let me read this. But the list of likely candidates isn't particularly long, according to Japan-based patent attorney Kiyoshi Kudahara. In a recent interview with Yahoo News, Kudahara opined that, given how the lawsuit was jointly filed by Nintendo and the Pokemon Company, the patents at the center of the case are plausibly owned by both parties. Based on this reasoning, the attorney narrowed down the list of possibilities to 28 patents. So there's only of the list that Nintendo has and the list that the Pokemon Company has, there are 28 that are joint owned patents between those two entities. Looking at the remaining group, Kidahara highlighted Japanese patent number whatever the fuck, which appears to be primarily centered on creature catching mechanics. This patent was first submitted in late July 2024 and granted the following month, after Nintendo and the Pokemon Company asked for an accelerated review process as part of a slightly more comprehensive patent family that describes the process of aiming a capture item at a character and releasing it using two inputs, an analog stick and a button press. So, they purposefully... This is like the big problem with patent law, is that patents are way too vague and far-reaching, and that, because of that, it basically causes a chilling effect on other developers that are designing systems that like might kind of be interpreted as a similar kind of thing. And these patent lawyers are specifically trained and get really good at making patent descriptions as broad-reaching as possible so that they can basically maximize their potential of patent lawsuits against other companies. They use vagueness and broad-reaching terms. Like, notice how they say a capture item. They don't say a capture sphere. You know, they don't say It's just items, so it can be literally anything. So, like, Palworld can't change the capture sphere, the Pokeball equivalent, to a cube and be okay, because the patent is worded item, so it can be anything. And it says using two inputs, an analog stick and a button press. So this is like the classic, you aim, you hold down a button to aim, and then, to start the aiming process, that you move the stick around, and then you release and it throws, right? That's what they're patenting.
So, by that logic, fishing games are fucking over this patent.
That's the problem. Is that where does the line get drawn? At what point does something become so ubiquitous that you can no longer file lawsuits about it?
Any game that has a game, like any game where you can throw a net to catch something, you're fucked.
Yeah, exactly. Because it's just item. I mean, literally,
The word item, yeah.
they basically
A fishing rod is an item.
they've basically patented hunting. You know, which is fucking insane. That's absolutely fucking insane. And a great example of the abuse of the system is the Nemesis system from Shadows of Mordor. So Warner Brothers patent. Do you remember that system at all?
Yeah.
It's fucking
it's awesome.
It's such a. It was one of the coolest mechanics I have ever seen in a game.
Yeah.
And you notice how no one else has used it or built upon it. Why is that? Because Warner Brothers patented that system and then shuttered the studio. So we're stuck for 7 years before that patent runs out, and people can actually use a system like that again, which fucking sucks because that system was so cool. So Kirihara described this as a killer patent that covers a wide variety of use cases. It seems like it would be hard to avoid if you want to make a Pokemon-like game, and it's easy to infringe if you're not careful. In a statement provided to Game Rant, veteran patent analyst Florian Mueller said that patent number bleh being central to Nintendo's lawsuit against Pocket Pair is a plausible theory. The request for an expedited review of patent number bleh also facilitated the approval of 3 other patents from Nintendo and the Pokemon Company, bleh, blue, and blee. Kirihara noted that amending an existing patent for specific litigation purposes is an established industry practice. So, a competitor comes out with a variation of a system that they created, and then they come in and they retroactively alter the patent to cover that specific mechanic, and then they use that to sue them. How fucked up is that? 2 of those 3 divisional patents elaborate on some additional specifics of creature capture, while the remaining one describes a system for riding creatures, which is something that's also possible to do in Palworld. Yeah, so this riding creature one is another one, and that's the idea where you can ride a Pokemon, and that Pokemon can convert from an aerial transportation mode to a ground transportation mode. That's the patent. So if you're on a creature that can fly as well as run, you have run afoul of that patent. How fucked is that?
Rest in peace, fucking Ark Survival.
How many games have literally any game with fucking World of Warcraft has flying mounts that you can run on the ground with?
Oh, dude, yeah, every single fucking MMO is fucked.
Griffins and Hogwarts, thank you, Umbra. Yeah, it's fucking insane. I'm sorry, but if this goes, and this is what's so fucking scary about this, is that Nintendo literally has a 100% success rate in lawsuits that they initiate. This is fucking terrifying.
Yeah, the fucking precedent from that.
Now, this guy,
not great.
This guy doesn't think that it actually has a lot of impact. So he's arguing that veteran patent and let me just read it. Philly Mueller told Game Rant that he doesn't expect the game case to have international consequences. Yeah, because that's the other key thing, is that this is being all these companies, Nintendo, the Pokemon Company, and Pocket Pair are all based out of Japan. So this is all happening exclusively under Japanese patent law.
Yeah.
Right. So at least
in the U.S., I imagine those
But even
someone
so,
a court would look at that law and say that is abusive, and then just throw it out.
Exactly. Now, the same
but
kind
in Japan,
well,
yeah.
You have to remember that I just brought up the Nemesis system. That was an American thing. It's the same problems are.
But it's also a very specific thing, though.
It is. It's much more specific, and this is the thing. It's American patent law does have the same problems, but they're nowhere near as bad as they are in Japan.
Yeah.
So that's basically his argument, is that because it's happening in Japan specifically. But I'm sorry, but what about all the Japanese developers that want to try to innovate on stuff?
Yeah.
Are they going to be terrified of Nintendo and the Pokemon Company, who can do whatever the fuck they want in that country, of just running over them and just killing their games? because this is what scares me about Palworld. Is like when this thing goes to court, what's to stop the Pokemon Company from getting granted a preliminary injunction, which would basically an injunction would basically force Palworld to cease operations until the case was resolved. So they force an injunction, shut down the game, and then just keep them locked up in the courts for years and years and years and drain their funds. Because Nintendo has unlimited funds in comparison to Pocket Pair. They can just keep them locked up in the courts until they go bankrupt. So they get the game shut down. They get the game shut down, and then they get bankrupted in the courts. Like,
yeah.
I don't know. I also saw this. So there was Force Gaming did a video about it, and there was a guy.
Don't make Nintendo look bad. Nintendo already looks bad. It's just, here's the thing: the people that play Nintendo games are A, children, they don't care, and B, women, they're fucking retarded.
And not only that, but if you know what's going on in Japan in regards to this case, the Japanese are largely in favor of Nintendo and Pokemon over Palworld. Yep. They actually want Nintendo to win in this case. So it won't let Nintendo make Nintendo look bad in Japan. They want this to happen. I don't know fucking why. It's obviously it's like a cultural, philosophical difference between our two cultures. But I also saw this. This was a comment that was left in a Force Gaming's video about it that I screenshotted because I thought it was interesting. So this is like a veteran in IP and patent law. Okay, and he's like prosecuted patent application shit. So this, according to what he's claiming, I'm just gonna assume that what he's saying is true about himself and his expertise. So that's the assumption going into this. So he says the main patent in the suit, Japanese patent bleh, was filed on December 22nd, 2021. The Japan-based priority on filing date, so Japanese whatever the fuck, has also has December 22nd, 2021 as its priority date. Other patents in the suit, bleh and blue, come to mind are continuations of children. So that whole thing, because there's this whole thing about like they filed a patent after Palworld came out. That's not really true because those filings were for renewals of an original patent, not for a brand new patent. So basically, they all claim priority back to the parent. So he's talking about children patent renewals that are under a parent patent. So they all two have a priority date of December 22nd, 2021. So he's basically saying here that legally, the patents that are being used were filed before Palworld released. That's what he's saying. And they said, now, if you review the patents, they are directed toward the new systems, an entire engine, really, because that's the capture system. Battling and capturing introduced in Pokemon Legends Arceus, and implemented in subsequently released mainline Pokemon games such as Scarlet and Violet. Basically, the throwing of a Pokeball, capturing of a Pokemon, battling normal Pokemon, battling boss Pokemon, and sending out / recalling a Pokemon in a 3D space. So that was like that whole like using a joystick and a button press to launch, an object in a virtual space. Yeah, that's what he's talking about. As some examples, Bleh has claims directing towards / provides technical specifications on increasing capture rate / capture. So this is like statistics on like when the ball hits the animal, like it takes in calculations on like the strength of the animal, the distance, the accuracy, and it runs it through an algorithm to figure out if you're gonna, what the gotcha rate is basically, right? It's just an RNG parameter calculator. I'm gonna skip the rest of this. But it says, Palworld released over 2 years after the priority date of the Japanese parent, just under 2 years after the release of PLA, and approximately 14 months after the release of Scarlet and Violet. I have to be honest, it sure seems like Palworld implements a lot of these systems, and I can't help but find it funny how there was a conversation around how blatantly and obviously Palworld copied Pokemon, but now that Nintendo is defending one of its main IPs, one of the most successful IPs in history, people are up in arms. He's got a point there.
Yeah.
He's got a point there. Prior art and validity come into play here, as they do with every patent suit. However, prior art landscape seems pretty barren. Even if games older than Pokemon implement similar ideas, it's irrelevant unless they have a patent for it and choose to enforce. And through the magic of computer-readable medium, or CRM, claims and its fairly robust specification, there are don't seem to be any glaringly obvious validity issues. So he's basically saying that the lawsuit actually does have legitimacy. That's what he's saying here, and he's being very legal about it, but that's what he's saying. And this is finally to address Force's points that games won't be able to release with patented systems until existing patents expire. This is simply not true. If a similar or even identical system/mechanics like engine is released with a substantially different technical implementation and/or is implemented in a technically superior way, then there is not infringement. Part of the point of requiring complete and thorough disclosures in order to obtain a patent is to promote this kind of iteration and technical improvement throughout the industry. So he's basically saying that legally, despite the breadth of the language of these patents, they actually aren't enforced that way. So he's basically saying that in his experience, the way he prosecutes this shit, because this guy is actually like a patent lawyer in the space, it's not really true how it works. I'm not going to read the rest of this, but the other thing that he goes into is the fact that like you can license patents. So if you want to, like, let's say a company comes along and they want to use something like the Nemesis system, they can buy a license from Warner Brothers for however many millions of dollars to basically use and iterate on that system. So he's basically saying that there are avenues to get around this, and it's not as much of a chilling effect as you might think. So that's all I have on this thing. I just feel like it was initially announced, and a couple people made videos about it, and then it just kind of got lost. So I felt like it might be good to just kind of reiterate like where we are, and where the arguments.
I learned a lot.
What both sides, kind of like both sides of the argument are here. Because there are, I think Nintendo does have a point, but at the same time, it looks it looks like it just looks shitty. You know, it looks petty. I think they might win the legal war, but they're not going to win the PR war on it. You know, so there's like that's kind of the game that's being played here. So we'll see. We'll see.
Implemented it in a technically superior way.
Mm-hmm.
And there's not an infringement. Like, yeah, dude, Palworld is fucking superior in every way. Every way.
Oh God, yeah.
Like, here's the thing. Like, I think a big part of the reason why people like I get what he's saying, right? Where it's like, yeah, Nintendo defending one of its main IPs and most successful IPs in history. Yeah, it's great. But all their fucking recent games have been shit.
Yeah, they have. And not just that, but pedigree.
And so if they can eliminate like competition, then they have no reason to ever improve.
And not just that, but like when you're in a courtroom, your pedigree is irrelevant, or it should be irrelevant. You know what I mean?
Yeah.
You shouldn't be able to like get like favorable legal decisions because you're the big boy in the room. You know what I mean? Like that's not how law and justice should be served.
Yeah, I agree.
So, but
it's like I get why they're doing it. I just think it's not just bad for Palworld. I think it's bad for Nintendo for them to not have competition and to just be able to just wipe out competition at a fucking whim in fucking court rather than by making a fucking superior product.
Yeah.
Like no one would fucking buy Palworld if fucking Pokemon games weren't so fucking utterly dog shit.
And this is the thing. It's like we'll see because you know if they go to court, which I'm sure they will, you know, discovery is going to happen, and what's going to happen at discovery? The source code is going to have to get revealed. That's what's going to have to happen. And if the source code for the Palworld system is different from the source code of the, you know, the Pokemon Arceus system, then Palworld wins. You know, so who knows? I don't know how I could see this falling on either side, honestly. But I heavily like my personal bias is I'm with you and everybody else in chat. I want Palworld to fucking wipe the floor with them. That's what I want to happen.
I fucking hate Nintendo.
I do too.
I've hated Nintendo for a long time. I never hated Nintendo, so I started working at GameStop. And like, just how absolutely fucking scummy they are, just kind of like bubble to the surface.
Dr. Frederick says the only core similarity is that PAL spheres, otherwise the parallels appear superficial. Or I can't see how Palworld infringes when Digimon did it. Well, that's the thing. Like, it's not the infringement that they're claiming isn't on design of like the creatures and stuff like that. It's purely on like game mechanics and systems. So it's not, unless that's what you're talking about. I don't know what I don't know anything about Digimon. So I don't know. Does Digimon use a similar capture system that Pokemon does? I don't know. Because if it does, then that's an argument in Palworld's favor. Because Palworld can turn to Digimon and say Digimon has like, you could have sued Digimon. You have grounds to sue Digimon for the same reasons, and yet you didn't, which makes you look malicious towards us because we're eating your lunch. You know what I mean? So I don't know. I have no clue about how Digimon works. Digimon is much more similar mechanically in how its combat works: fixed moves, turn-based combat, etc. Well, that's not how Palworld does it though. But I guess at the time when Pokemon came up, Digimon, yeah, it would have been like turn-based creature combat. So I don't know. I mean, but that's the thing though. It's like that kind of shit. Like Palworld needs to start making those I'm sure that they're building those kinds of arguments. You know, Palworld, they have a legal team that they unfortunately have to like pour a bunch of development money into now, which sucks. But I'm sure that their legal team is is aware of those kinds of arguments that they're building. They have to be. But the thing is, Umber says that that's not the patent. Has a real-time combat, which is, as far as I understand, no Pokemon game does. What? But it's not. It's not the combat itself. It's the throwing. It's the capture mechanic. It's throwing an object that then captures a creature. It's not the combat. So, it's the capture mechanic. It's the hunting mechanic. That's the patent at play here. It has nothing to do with the combat itself. That happens after the capture and release mechanic. It's the PAL spheres, purely that. Yes, exactly. That's what it is. It's specifically the mechanic of the PAL spheres.